My lord, yes. So I have 15 minutes.
Yes.
I have, I think, 8 or 9 very short points to make. They best be short, I think, in the circumstances. I think at the end of yesterday we were looking at the impecuniosity point, and my lord asked where the evidence was of that, and I began to take you to the appellant's original witness statement. I don't propose to take you through that in detail now. I don't think there's time, sadly. But we did look at some parts of it from paragraph 45 onwards. And up into paragraph 64, she talks about her position in broad terms between 2008 and 2020. We didn't get to paragraph 69, which, for your lordship's notes perhaps, but if you wish to turn to it, it's page 130 in the supplemental bundle. Where she does summarise the position by saying, in relation to part of the defence, the 16-month delay, alleged delay in getting counsel's advice in May 2020 was due to her impecuniosity and the issues referred to above, and in the personal relationship between me and Mr. Morgan. So she does make clear there that impecuniosity was a major cause of that delay. She was not cross-examined at length on the impecuniosity issue, but she did respond. And again, for your lordship's reference, this is page 159 in the December application bundle in the transcript. She's questioned at pages 158 to 159 on this. And in addition to describing how Mr. Morgan acted on her behalf, at page 159G, she's asked, you did nothing about getting that advice in 2018, did you? And her response is, no, because my finances wouldn't allow. And it was, yeah, no, I didn't. He was helping, obviously free of charge, and I was asking for a favour to help me. So again, summarising her position in 2018. Now, yesterday, we looked at part of the judgment where His Honour Judge Russon referred to the possibility of the appellant obtaining a job in 2014. And my submission yesterday was that that date appeared to have been pulled from nowhere. Looking back at the judgment this morning, it's still not clear to me, but I wonder if the judge picked that date because that would be the end of the primary limitation period. And earlier in the judgment, he talks about the primary limitation period expiring in 2014. But in my submission, that date is, for our purposes, a red herring. The case pleaded by the defendant on constructive knowledge was that if the appellant didn't acquire constructive knowledge in 2008-2009, then she did so in 2018. And in relation to constructive knowledge, the burden is on the defendant to raise the issue. The overall legal burden remains with the claimant in terms of section 14A, but in terms of the case that she needs to meet, as I say, the burden rests on the defendant to raise the date at which it says she acquired constructive knowledge. And so that is why my submission, the case was directed towards, in terms of her impecuniosity, the later period, 2017 through to 2020. And that is why her witness statement refers to that period, and she was cross-examined about that period. In fact, the reason for that, it seems, the reason for the defendant putting its case that way is that its case was premised on the discovery of Mr. Mahan's greater wealth in 2017-2018. So that, the defendant said, in its alternative case, alternative to the 2008-2009 position, was a trigger for constructive knowledge. And so that makes sense of the defendant's case and why the claimant, now appellant, responded in that way. yesterday we mentioned the fresh evidence, and that does also deal with impecuniosity. So if your lordships are minded to take that into account, it's in the December application bundle. The witness statement is at page 80. That's the witness statement of the appellant. I don't think I have time to take your lordships through it now. May I just give you some paragraph references, please?
So page 80?
Page 80 of the December application bundle, my lord, yes.
Oh, yes, sorry. I've got it, sorry.
Yes, and the material parts begin at page 81. It's paragraph 6, paragraph 24, 27, 29, and then most particularly she deals head on with the impecuniosity issue in response to the witness statement from my learned friends instructing the solicitor the fresh evidence that the respondent seeks to rely on. She deals at paragraphs 35 to 39 with her impecuniosity in that later period. So I hope that's sufficient to direct your lordships to the evidence on impecuniosity. Of course, it is right to note that although it was not incumbent upon my client, the appellant, to plead in or indeed evidence in detail her position as at 2014, because that was not the defendant's case, insofar as she needs to rely on the impecuniosity having been caused by the original negligence of the defendant, then in a sense the whole period matters. Otherwise there might be a break in the chain of that causation. But in my submission, the evidence is sufficiently clear that the settlement in 2008 left her in a position that was an unhappy one, particularly once the economic crisis hit in 2008, 2009, the issues over the house and so on, and that her position did not improve at all up until she received counsel's advice in May 2020. May I just move briefly on to ground 7, please? So ground 7 relates in particular to the involvement of Mr. Morgan, and this is in relation to paragraphs 165 and 166 of the judgment, where the judge found that the appellant was not entitled to rely on the proviso as a result of, to section 14A10, as a result of relying on the assistance of Mr. Morgan, because both the appellant and Mr. Morgan knew that he was not a family law specialist, and also there was insufficient justification for Mr. Morgan's delay in instructing counsel. In my submission, the judge was wrong to reach that conclusion because her reliance on Mr. Morgan stems precisely from the impecuniosity which I have referred to. And so she had no other option other than to rely on his assistance, his pro bono, as it were, non-expert assistance, expert only in the sense of being able to marshal the papers, and a facilitator who could instruct counsel, but who could provide no meaningful opinion of his own on the prospects of reopening the settlement, or indeed whether or not Mary Kay and the respondent would be negligent. Now, Mr. Morgan's delay in considering those papers has been criticised, and one might think that he was a little slow to deal with it, but that is not a matter which should be visited upon the appellant in my submission. And I just want to take your lordships to one part of my learned friend's skeleton, not wishing to preempt his submissions too much, but in his skeleton, which is at tab 12 of the core bundle, page 197, paragraph 51, in relation to ground 7, my learned friend says Mr. Morgan cannot be an expert under section 14A10 because as he emphasised, he has no experience in matrimonial finance or corresponding professional liability. As was held in Henderson in the context of Section 14.3b, the proviso does not give an extended period limitation to a person whose solicitor acts dilatorily in acquiring knowledge. In my submission, that seems to conflate two things, and it's not that the appellant is relying on having consulted Mr. Morgan as an expert, so he is not the expert whose advice it was reasonable for her to seek for the purpose of Section 14a10 and the proviso thereto. He was merely, as I say, the facilitator or the conduit to the expert advice, and the appellant's case rests on her having taken all reasonable steps in her circumstances, and in particular in her impecunious circumstances, to have got the expert advice of counsel via Mr. Morgan, but not relying on Mr. Morgan as an expert. My final point, my lords, relates to ground 8, which I touched upon yesterday. And your lordships may already have this, but for completeness, if I could ask your lordships to turn, please, in the core bundle to page 85. This is ground 8 of the appeal, which is the judge's error in my submission in failing to take account of the delay in 2019, or of the reasons for delay in 2019. So, my lords, if you could look at paragraph 160, please, on page 85. The judge found there was no reason why the advice sought in March 2020 could not have been sought and obtained. That exercise in 2020 took a couple of months by the end of 2018. There is no excuse for the delay on Miss Kay's part during the second half of 2018, the whole of 2019. The personal reasons she relied upon are irrelevant. The error in my submission, in particular in that paragraph, is the suggestion that there was no excuse for the delay in the whole of 2019, when it is quite clear from the documents which I've taken you that between February and July 2019, the appellant was waiting for an answer as to whether or not the respondent had the Hildebrand bundle. She, of course, relies on her inability to get help anywhere else other than through Mr. Morgan in relation to the second half of 2018. So, my lords, those are my submissions, unless I can assist you any further.
No, I don't detect any questions, so thank you very much, Mr. Hall. Mr. Wilton.
Thank you, my lords. My lords, may I start with a maxim, whilst perhaps coffee is still percolating through the veins of the court. Vigilantibus non dormientibus jura subvenient. The law assists the vigilant, not those who sleep on their rights. My lords, I say that that's a theme that one can see in the Limitation Act, relevant parts of the Limitation Act, and in the case law. And it's the essential reason why this appeal should fail. Because there was an opportunity, a reasonable opportunity to take action much earlier, either in 2008, 2009, or in 2017, 2018. And essentially for that reason, the judge was correct in his conclusions. My lords, I'm going to start by looking at the pleading of the claimant's case. I want to take the court to a little bit more in the particulars of claim to make the point that really the claimant's case is much wider than simply a complaint that she did not have a nominal spousal maintenance order. That element of the case has assumed a centrality, and the reason for that is because of the Whitcomb decision and the analogy my only friend draws with the Whitcomb decision. But our submission is that that's not a fair characterisation of what the case is about. And when considering what the damage was, and therefore what the knowledge of attributability was, and what we should be concerned with in those respects, one needs to look at the width of the case that's actually pleaded, which is different. I'm then going to look at the statute and look at some points of law that have arisen, and then having cleared, as it were, the law out of the way, I'm going to come back to the facts and seek to sum up why we contend that the judge was right in his conclusion, or conclusions rather. Bearing in mind, of course, that for the appeal to succeed, the appellant needs to demonstrate that there was no actual constructive knowledge in 2008, 2009, and no constructive knowledge in 2017, 18. So in effect, that the judge was wrong in all his essential conclusions. So, Lords, if I can start, therefore, with looking in a little bit more detail at the pleaded case, picking that up with the particulars of claim in the core bundle, starting behind tab 7. If I could just preface my remarks by saying that in the round, what we contend the particulars of claim demonstrates is that it's a case where the claimant believed throughout, the appellant believed throughout, that her husband had hidden assets of various kinds, and she knew it was possible to investigate further, with a view, obviously, to seeking to demonstrate that the distributable funds, the distributable assets, were significantly larger. And the point of doing that, as was self-evident, was to achieve a more generous outcome. That was subject to the obstacle of costs. The claimant was hard-pressed financially. But her case is effectively that the wrong decision was taken. I was encouraged, advised to settle on a clean break basis with the features of the settlement that we know about, because my solicitor took the view that that was the best solution achievable in the circumstances, and that the alternative course, which she knew about, of pressing further for further investigation and for different forms of provision, was not followed. So it is a case factually which has those features. She knows there's an alternative course. She's advised not to pursue it. She knows that's what happened. That's why she settles, with some frustration and reluctance, but that's why she settles. That's her state of mind during the litigation.
It might very well turn out, if this case went to trial on the merits, that for those sorts of reasons there was no negligence at all. But for limitation, given that we are faced with a preliminary issue, we have to assume that there was, don't we?
My Lords, I absolutely accept that. But nevertheless, one needs to look at what the case is, first of all to see what the claimant's own knowledge is, and secondly to get a sense of what the damage is that's in issue here. Is it just the nominal spousal maintenance order, or does it go wider than that? And if it goes wider than that, one needs to have a proper appreciation of that factor when one comes to consider the central question of attributability. Because attributability, of course, is when somebody has knowledge that the damage, so one needs to get that clear, is attributable to the acts and omissions said to constitute negligence. So the way the case is pleaded, the width of the case, the characterisation of the case at the damage stage is, in my submission, important.
Well, the particulars of claim would tell us what the alleged act of negligence is.
Indeed.
And the damage is the damage that flows from that.
Indeed.
And then, depending on what the alleged act of negligence is, and if there's damages, put broadly, the undervalued settlement,
Yes.
then the question is, what did she know about that damage in the light of what she says was the act of negligence? That's the way you put it, I think.
Indeed, precisely so, my Lord. And this is not a case, to anticipate some things I'll say later, like the Whitcomb case, where the only thing that was being sought is the value, the lost chance of benefiting from an award of provisional damages, and specifically the opportunity to come back for further damages, which such a provision would have enabled the claimant to have in that case. But as we'll see, that's not what is pleaded here. It is not a case which says, well, what I have lost, the damage I have sustained, is the lost opportunity to come back, 3 years, 5 years, whatever it was, to seek further provision from the court under the terms of a nominal spousal maintenance order. That simply is not the case that my clients are facing. So, my Lords, it's a case much wider than that. It's a case where there was a choice about how to conduct the financial remedies proceedings. It's a case where the claimant knew further investigations were possible. It's where she knew you could have a maintenance award. She knew you could have a pension award. She knew you could have an award which could set aside the ownership of the disposal of the husband's interests in the Wall House property. She knew all of those things, and the pleading demonstrates that which is why it's an important place to start in my submission. Criminals, just having set up my stall in that way, can I just follow through the pleading to see the way it addresses those particular points? And if you could start, please, at paragraph 27, page 99 of the core bundle. I think we glanced at this already. I don't think the detail matters. What matters is the plea that as a result of her own knowledge, together with material in the Hildebrand bundle, which of course the appellant herself had put together, she believed the following things. And one can see reference to offshore bank accounts, an American Express card, credit card, a particular business, interest in various companies, beneficiary of a discretionary trust, a particular pension scheme, against Martin's self-invested personal pension over the page, shareholdings, and so on. And therefore, the Form E was misleading. So, the claimant's belief is that there is a substantial amount of additional wealth of different kinds in existence, which is not being candidly disclosed. The second point I guess from the pleading is that the claimant gives instructions about that to the defendant. So if we look at paragraph 30 at the bottom of page 100 and follow that over to the next page, we see some initial advice from my client, and we see some information travelling back from the appellant. So at D, tight-knit professionals and would be difficult. She had hoped that Munchies would fight hard for her, enable her to stay in Matter Cottage. If we look at little I, Mr. Mann had lied to her in the past, stopped paying her credit card, wasn't paying any child maintenance, gave sundry further instructions about Mr. Mann's finances, including £5,000 a month, offshore assets and bank accounts, and the other matters set out in paragraph 27 above. So the solicitor is on notice of the client's beliefs as to the existence of additional wealth of that kind. And we get the first indication of what the advice was from the solicitor at page 102, advised that a clean break was the best option, and that the dispute had got out of hand. At 32, we can see the first directions appointments and what happened there. Costs are excessive, says Mrs. K. Claimant needed to look at the money in the pot right now. If we're lucky, we may be able to prove that Mr. Mann has money offshore. We shouldn't expect to get to the bottom of it. And then at 34, amendments to the questionnaire and the complaint that the solicitor agreed to the removal of some questions which were highly pertinent to prove concealed wealth, or potentially to prove concealed wealth. I'm sorry, 34 following on from that, the advice that the claimant needed to be able to work herself and would feel better not to be reliant on Mr. Mann. Then an extensive letter of advice, 23rd of January 2008, and some discussion about pensions and the possibility of pension provision. At 37, some further advice, writing a letter to the claimant, an argument that the interest in Woolhouse had been transferred to his family at an undervalue, but because the claimant had been aware of the transfer and the price, the argument was impliedly weak. Discussion of a 5-year maintenance order, and that there should be a 50% pension sharing order. At 38, a complaint that didn't advise the claimant about a nominal spousal maintenance order or about the merits of a pension sharing order, and so forth. At 39, without prejudice offer savers to costs. Elements of that, as one can see, include that there would be a significantly larger lump sum of £150,000, spousal maintenance in little g, certain child maintenance, and insurance and private health care, and a pension sharing order. At paragraph 40, the reference to the FDR, where it was noted in a document submitted on that occasion that there may be ongoing issues. That full disclosure has not been given. And at 41, at the FDR itself, we can then see the way in which those negotiations took place. And a key trigger for settlement at page 107 of the bundle, towards the end of paragraph 41, under E little Roman 3, Mrs. K's alleged advice that the appellant was a strong woman, didn't need to worry about the maintenance pension or the house, etc. She could start again. She was young. So, my lords, we submit that that shows that there's a high level of discussion and understanding on the claimant's part as to the forms of provision that the court can, in principle, make, including maintenance, pension sharing, transfer of lump sums, asset redistribution. It shows that the claimant, the appellant, was certain, in her mind, that there was concealed wealth and that further inquiries could produce further evidence about that. And it shows that there was a choice. In difficult circumstances where the appellant had limited funds, and that was the reason why she'd left Munchies, who she felt had overcharged her, in difficult circumstances, the decision taken was on proportionality grounds and on the basis of the solicitor's advice, we will settle, we'll take the clean break. If we then look, please, to see the way that the breaches of duty are identified, we see that at paragraph 60 on page 113 of the bundle, and they're very wide-ranging. And so failing to advise adequately in relation to options for investigation, failing to consider the evidence and documents placed before the defendant, failing to seek details of what means the claimant had to fund further litigation, failing to recommend further investigations and disclosure, failing to seek accountancy evidence, failing to seek a pensions report, wrongly stating there was no point in pursuing such investigations, wrongly advising the prospects of obtaining an avoidance of disposition order were weak, failing to consider the options under the Act, agreeing to the amendments in the questionnaire, failing to advise the claimant of the availability of a nominal spousal maintenance order. So, my lords, clearly it's an element. It's in the mix, as it were, but it is only an element, alongside very much else in the case, and recommending settlement when it wasn't advisable to settle, or at least not on those terms. And one can see that all followed through, as it were, those many streams, as it were, that are contributing to the flow of the case. When one looks at paragraph 61, and looks at the loss and damage that the appellant alleges on the back of that. And the way that the pleader deals with that, paragraph 61, is first of all to set out some more particulars of causation, that there would have been some further investigations and there would have been different forms of relief of different kinds sought in relation to pensions, avoidance of disposition and a nominal spousal maintenance order, and if necessary, at 7, that the appellant would have borrowed or sought gifts of money from her parents to fund the above actions. There was a very strong chance, alternatively a substantial chance, that Mr. Mann would have agreed a settlement, or if not, a strong chance, alternatively a substantial chance, that the court would have made a final order, materially more favourable to the claimant. Most likely, in each case, based on the claimant receiving 50% of the value of Mr. Mann's true assets, thus ongoing substantial maintenance at least for the 2 children, and nominal maintenance for the claimant. And then a little C at the bottom of that page, where, as it were, there's an attempt, the best attempt that the appellant can undertake at this stage, to quantify what the loss is, and to indeed to specify what the particular features of the loss are. First of all, the 50% of the value in Wall House, £500,000, 50% of the value of Mr. Mann's other assets as at 2008, £380,000, increased maintenance for the 2 children, comprising school fees and other maintenance, and a reasonable proportion of the true value of Mr. Mann's pension funds as at 2008. So, my lords, if one looks at that and one asks, well, what is this case about? it is about a number of different things, but it's essentially focused on damage which I would suggest could fairly be characterised as an unfair and inadequate settlement which did not afford adequate income or capital provision to the appellant. And it would not be appropriate in my submission to say that this is a case about the failure to obtain a nominal spousal maintenance order. That is to allow the tail to wag the dog in our submission. That's one element of the form of relief which it is suggested could have been obtained. But it's only one element. And indeed, the pleader doesn't even price, as it were, the value of that relief had it been obtained. There's no attempt to say, well, if we'd had that, then we would have gone back to court in year X under a nominal spousal maintenance order, which would have been for a term of, say, 10 years. And on that occasion, for the following plausible reasons, this is the approximate estimation of what we might have recovered on such an occasion.
Do we know how long these things generally do last in family proceedings?
I think all we know is that there was some evidence, and my learned friend will tell me if I've unfairly recollected this, that they can be of an infinite duration or they can be for a fixed term. Say, for instance, until children have left education.
I mean, looking at 61A6, that says that the nominal spousal maintenance order was being sought to ensure she could return at some later point if he came into greater wealth, particularly if wealth represented the fruition of assets that he'd hidden. So there, the nominal spousal thingamabob is connected again with things have been hidden, and it's a way of getting at the things that have been hidden.
Yes, I accept that, but it is, in my submission, on any fair reading of the pleadings, that is not what the case is about, or certainly not all the case is about. It's only one element of it. And after all, just to say the obvious, that wouldn't have been of any use in order to get a claim to the value of all house, or the value of the avoiding that disposition in some way. It wouldn't have helped with the pensions.
Yes, I suppose I would say actually the problem is the hidden assets, and this is a way of getting at the hidden assets, but there are other ways of getting at the hidden assets, not the nominal spouse thing. It's a means of rectifying the underlying problem, you would say, I suppose.
So, our submission, on the basis of that, is that when one asks what is the case about, what is the damage that the appellant is pursuing a claim for, then it is, as I say, the unfair and inadequate settlement of a broad character, the kind that the pleading indicates.
Sorry, I am still on the last point. If she did have a nominal spousal maintenance order and she went back, she'd still have to show that the chap had hidden the money and he was better off than he'd claimed. So in a sense, it's a way into...
Well, not necessarily, I suspect. I mean, I'm not a family expert, so I need to be a little bit careful. But my understanding is that if you have such an order, then you have an unfettered right to return to court if you think, in the light of the situation as it develops, you can persuade the court to make an order in your favour for maintenance.
So even if he won the lottery, which has nothing to do with the marriage, just having bought a lucky ticket, the former wife 20 years later could come back and say, we've won the lottery now, I'd like to have some of that, please.
Well, I'm improvising somewhat, my lords, but I suspect yes is the answer to that. I suspect yes is the answer to that. Because if someone was in very difficult financial circumstances and the difference between their position and the position of the spouse was so dramatic, then that might be a strong equitable foundation for an order, I anticipate. What we say is that that's only one element of the case. And indeed, the most of the case is focused upon the proposition that by settlement or by order, as at the time of the resolution of the proceedings, there would have been significantly more favourable provision for this claimant in the form of maintenance, in the form of capital provision, in the form of setting aside the disposition of Wall House and the consequences of an order of that kind.
So you say, do you, that for the purpose of section 14A, material facts about the damage and knowledge that the damage was attributable, one has to take a broad view of what the damage is
Yes.
by reference to the pleading as a whole.
I do.
That's essentially your
I do.
submission, is it?
I do,
On
my
this, on
lord.
this aspect.
Yes, absolutely. And that's a convenient point of departure, if I may, for looking at section 14. So if we could have a look at that in the authorities bundle.
So we can put the pleading away.
Yes, please. Yes, thank you. So in the authorities bundle, my lords, it comes at page 16. And picking it up if we can at subsection 7, material facts about the damage. Such facts about the damage as would lead a reasonable person who would suffer such damage to consider it sufficiently serious to justify his instituted proceedings for damages against the defendant who didn't dispute liability and was able to satisfy a judgment. And, my lords, well, when was that knowledge reached? What is that knowledge, first of all? Well, it's knowledge concerned with, as it were, the gravity of the damage.
Well, you've got to go back, I think, to 5, haven't you? The starting date for reckoning the period of limitation is the earliest date in which the plaintiff had the knowledge required for bringing an action. That's the test, and 6 and 7 are defining that.
I should have done it a long way around, but my lord, yes, I absolutely agree. But when we get to 7 with the first element of that, the material facts point about the damage, then the nature of the facts that you need to know about are facts which tell you that you have suffered damage of a more than de minimis character. Given the particular hypothesis which that subsection asks you to focus upon, the ability to bring a claim against a defendant who didn't dispute liability and was able to satisfy a judgment. So it's not a very high bar. You need
So you say that the claimant actually had all the relevant knowledge in 2008-9,
yes,
and the only thing she didn't know was about this non-spousal maintenance order, nominal, whatever the word is, but that's a detail,
yes.
To use the judge's word, and that we don't even get to subsection 10.
Well, I mean, I think we do get to that.
Well, subsection 10 extends knowledge which a person doesn't actually have to things which they might reasonably have. But if she actually knew
Yes.
all the facts, that she hadn't been advised about this, that, and the other,
Certainly
why
on the
do we
damage.
get there?
Certainly on the damage point, because the damage point is, in our submission, self-evident. I mean, I'll come back to the facts later. But if you look at the position in 2008, 2009, then the claimant is confronted by not only is it an unfair settlement, as she has always perceived it to be, because she did not get a fair share of the assets which she believes were available, but it's hitting her hard. I mean, the financial world is in difficulty, of course, at that time. I think the September 2009 was Lehman Brothers going into insolvency. So those factors are operating too, but it's hitting her. And her absolute belief at that time is that she had an unfair and inadequate settlement. And on her case, she did.
The damages suffered are the damage in respect to which damages are claimed. 6A are the material facts about the damage in respect to which damages are claimed. And the damages claimed are 1,274,000, comprised of the various elements you've shown us at 116.
Yes, well, but one doesn't need to know, as it were, everything you might put into pleading.
No, but that's at least that. That actually reserves the right to claim other things as well. But at least at that stage, the damages claimed and the material facts you need to know about was not just the non-spousal order, but the 1.2 million that she claimed in the various things, the sharing, the ward house, and so on.
Well, in my submission, one needs to. I mean, I'll come back to the authorities on this, but one needs to. It's got to be put at a certain level of abstraction.
Yeah.
So, you know, if it's an injury case, you may know you've got a head injury. It may be many years before you know what precise injury that is. It may be many years before you know what forms of financial loss you might be able to claim for, referable to the injury. But you know you've suffered an injury the morning you wake up in hospital and you're conscious, if you are conscious, that that you've suffered a head injury. And in this case, the claimant has, by that stage, on her case, sustained an unfair and inadequate settlement. It's exposing her to the consequences, the very difficult consequences that she's having to contend with. And indeed, it looks as though things are going to get worse because the market's going down. The principal asset she's left with is diminishing in value. She's looking at the potential of having to sell, and she fears negative equity. So she fears being left with little or nothing. So in my submission, that in this case, and there isn't much argument on the appeal about damage, in fact.
It's more about subsection 8.
But it's important to start with that because then one has the connection to attributability, which we see at subparagraph 8. The other facts are that the damage was attributable in whole or in part to the act or omission which is alleged to constitute negligence. And so one has to have a consistent sense, however one characterise it, one has to have a consistent sense of what the damage is for the purposes of asking the question that subparagraph 8 requires one to ask. And in this situation, in our submission, the question is this. When was it that the claimant knew, or could reasonably have discovered, that there was reason to think that her unfair and inadequate settlement might be due to deficient advice from the defendant? So the question is, again, the question is not when did she have reason to think that the inability to go back to court for spousal maintenance was due to any deficiency in the advice, if I can use that word. And when we look at the authorities on actual knowledge in relation to that, your lordships were taken, I think, to the relevant bits in Hayward, but they're in my skeleton. But if I could just remind your lordships that where Lord Nichols ends up, certainly at paragraph 11 in Hayward.
Should we turn up Hayward?
Let's have a look at Hayward.
I don't find this entirely easy.
So yes, my lord, it starts at page 96. I'm going to take your lordships to page 100 of the bundle at paragraph 11 of the report. Dealing with the expression attributable at paragraph 11, the statutory provisions do not require merely knowledge of the acts or omissions alleged to constitute negligence. They require knowledge that the damage was attributable, in whole or in part, to those acts or omissions. Consistently with the underlying statutory purpose, attributable has been interpreted by the courts to mean a real possibility, not a fanciful one, a possible cause for the damage, as opposed to a probable one.
I'm so sorry, I'm behind you. Which paragraph?
Paragraph 11, my lord.
11, sorry.
Thus, paraphrasing, time doesn't begin to run against a claimant until he knows there's a real possibility this damage was caused by the act or omission in question. And again, as other elements of the judgment explain, it doesn't mean that the claimant needs to know everything that a counsel would put in a pleading in terms of the acts and omissions. One needs to step back a bit and look, and it's a question of characterisation once again, but the essential complaint. What is the essential complaint? When did you know as a real possibility that in this case, the unfair and inadequate settlement might be due to deficient advice of the defendant of the kind that you complain about? My lords, just while we're on that, can I just take your lordships back to Wickham in the Court of Appeal?
And are you going into Hayward anymore?
Not at this stage, my lords, no.
Okay.
Wickham in the Court of Appeal begins at 248 in the bundle. And at paragraphs 55 to 7 of the report, which we find on page 262, we get the reference back to the first instance decision in Wickham as to what Hayward means and what actual knowledge requires.
Sorry,
and we get the Court of Appeal's review of that.
Sorry, which paragraphs did you say?
It's 55 to 57, my
Yep.
lord, at 262.
Yes.
So Mr. Justice Bourne ultimately drew from Hayward the following principles. Where the essence of the allegation of negligence is the giving of wrong advice, time will not start to run until the claimant has some reason to consider that the advice may have been wrong. And the judge continued, similarly, where the essence of the allegation is an omission to give necessary advice, time will not start to run until the claimant has some reason to consider that the omitted advice should have been given. And there was some quarrel from Mr. Claimant about that, but we can see a slight reformulation of that second point in the last sentence of paragraph 57. The judge is saying no more that in a case of omission, time will not start to run until the claimant has some reason to consider that the necessary advice has not been given. So some reason. I mean, any paraphrase is dangerous, particularly with a statute, of course, but it's on inquiry, if I can use that as shorthand for what is being spoken about here. When is the claimant on inquiry that the damage of which they have knowledge, there's a real possibility that might be due to deficient advice of the kind that they ultimately complain about.
I mean, the Act does say the damage was attributable, not might be attributable.
It does say that, my lords, but the authorities have commented on that.
Diluted Parliament's intention, yes.
They've moved it a little bit.
And so you're happy with that formulation?
Yes.
And I must admit, going back to Hayward, or indeed the statute, you have to know about the act or omission, which is alleged to constitute negligence. But on the other hand, you don't have to know that there's a legal wrong. And Lord Nichols tries to work through that, and I suppose he ends up with what is reflected in these paragraphs, which is there has to be something.
Yes.
Yeah.
And again, one is trying, of course, one is trying to search for is as it were, a meaning on practical level of knowledge that one can look for in a claimant. In circumstances, of course, where most claimants are not lawyers, and they won't have, and possibly will never have, unless they memorise the particulars of claim, the particular way in which the claim might be articulated by a lawyer. But one's looking for a sensible, commonsensical, if I put it that way, sense of the gist of what it was that a professional advisor in this kind of case got wrong. May have got wrong. Now, my lords, one of the oddities about that, one might think, is that, well, where is the forensic space for constructive knowledge? Because if time is going to start running when you know there's a real possibility that your damage is due to deficient advice that the defendant gave, then when are you going to have a constructive knowledge case? That's a difficult question. And one of the reasons, I suspect, why there aren't many constructive knowledge cases since Hayward is because people are focused on
Actual knowledge requires so little.
Actual knowledge does it. But not in this case. I mean, perhaps on a bootstraps basis, obviously constructive knowledge was very much an issue. But if we look at constructive knowledge, I mean, plainly the focus is on the acquisition of knowledge of facts. That's what the statute is dealing with. And the relevant facts for present purposes are to do with attribution. That is, the real possibility that the damage might be due to deficient advice. And so for this purpose, one is assuming that the knowledge that the claimant had did not give her that state of mind. And so that she did, and if one assumes that, then I accept we're in the situation of considering the need for input from a lawyer, expert in the area in question.
here it is such a difficult case, and Whitcomb is an odd case in many ways. Did they actually consider, when they used the word some reason to consider, your phrase on inquiry, whether that meant that they'd plunged as far down the section as subsection 10, or were they actively and consciously tying themselves to subsection 8, or is there no indication of what their lordships are doing?
There's no, from recollection, there's no consideration of, well, constructive knowledge wasn't argued in Whitcomb, just as it wasn't argued in Hayward. But they're both actual knowledge cases.
But one would obviously hope that they had borne in mind subsection 10 in working out what.
Yes, but and again, I apologise if I've misrecollected something, but I don't believe in the judgment of. I was at first instance, I didn't do the Court of Appeal hearing in Whitcomb. I don't believe that there is a discussion of how this fits in with constructive knowledge. So that is one of the unresolved puzzles, as it were, that's there as a result of the state of the authority.
It may be that these words trigger and constructive are unhelpful, and if everyone had tied it to the words of the Act and called it subsection 8, knowledge of facts attributing the damage, and subsection 10, things they would have found out if they'd made the reasonable inquiries, it might have been better, because they don't seem to draw the distinction.
Well, my Lord, I'm not sure it's necessary for my case to adopt that proposition, but I mean, that's a possibility, clearly.
Yeah.
Well, Lady Justice Thirlwall says in paragraph 21 that this is a case about actual knowledge, and constructive knowledge, as defined in section 14A10, was not argued.
Yes. Well, exactly.
So she did think she was dealing with
Actual
8, subsection 8 then.
But, my Lord, on the assumption we're not in an actual knowledge situation, so if we don't persuade your lordships that the judge was right on actual knowledge in 2008-9, then obviously we need to look at how constructive knowledge works under the Act. And again, it's focused on facts, and it's focused on when you know or could, critically, when you could discover facts. It's about discoverability. And in my submission, this is the statutory balance that Section 14A achieves. 3 years from discovery, or discoverability. And it's an inherently objective approach, discoverability. Claimants, of course, may discover things earlier rather than later, and their individual characteristics may affect the date of their actual discovery of material facts or knowledge of attribution. But when it comes to discoverability, what we're concerned with in my submission is where you're in a situation where, objectively, you had a fair opportunity to discover the facts you needed to know.
Well, Mr. Hall accepts that there was discoverability in that sense, but he says that he gets off the hook because of the concluding words of the subsection.
Yes, certainly he accepts that for 2017-18, and I think
I thought for 2008-9 as well, yes.
As well, yes, I'm grateful. Yes. So we need to look at knowledge he might reasonably have been expected to acquire from facts observable or ascertainable by him, or from facts ascertainable by him with the help of appropriate expert advice which it's reasonable for him to seek. And those are all objective questions in our submission. And I accept it's not as clear as it might be. It doesn't say which a reasonable person in those circumstances would have discovered, or a reasonable person would have sought such advice. But nevertheless, although the syntax is not as clear as it could be, that is the clear direction of the statute in our submission.
I follow your point about the direction. Some of it has to be individual, doesn't it? I mean, the authorities say, will you take into account shyness or whatever? But there must be limits to the extent to which you ignore the personal circumstances.
Well, there are two limits in our submission. Well, one clear limit, and one where the authorities haven't quite reached the landing ground yet, but it's not relevant for the purpose of this case. The clear limit is that you have to have regard to the circumstances in which the claimant is in. And we saw that in Gravguard, my own friend's submissions, taking the court to that yesterday. It's not any old claimant, it's a claimant placed as the claimant in question was. So what would a reasonable person do in those circumstances? Individual peculiarities, as it were, about the claimant's character or intelligence, or I would say means, are, however, irrelevant. The only additional factor in our submission where the authorities give any support for paying regard to the individual claimant is the suggestion in the Adams case that if the very ability to discover facts, an individual's very ability to discover facts, has been hindered or is hindered by some form of incapacity of some kind, whether it's dyslexia, whether it's blindness, anything, something of that sort, then that is something which the court can take account of. Now, my lords, that was thrown up in debate, as it were, in the Adams case, but as you also may remember from the discussion of that case, it didn't actually succeed that point for the claimant because there wasn't actually any evidence that his dyslexia did prevent him from conducting the inquiries which the court thought a reasonable person should undertake. So I would certainly accept, I can concede the point, as it were, because I submit it's not relevant, that if this appellant had dyslexia, or was blind, or had some other form of disadvantage which made it more difficult for her to acquire knowledge of facts, then that could feed into the mix. But it's a different thing entirely in our submission to say that, oh, well, you can have regard to something, as it were, external to the person concerned, such as their financial position.
Are you going to come back to this, or should I explore with you now the potential limits to all this?
I'm going to come back to it.
Yes.
But I just wanted to, trotting through the statutes, outline the shape of our overall submissions. And that takes me, I think, to the proviso. So if one has the situation that we do have, that it is reasonable to seek expert advice, then looking at the proviso, how does that
Sorry, I
work?
was trying to think of an example. So if you injured somebody in a car crash and you caused them very considerable brain damage and they can assimilate information slowly but over years, it takes a long time, you've got to sit them down, tell them a bit more, then it would not be reasonable to expect them to get the information about the damage as quickly as you would as a KC. It would be, how reasonable was it for a person having suffered that injury which has affected his cognitive powers?
Yes, I don't need, as again, I don't need to make the concession, but I'm happy with it.
Right.
In the sense that, because it's not this case. But
No, I'm trying to work out what would be within it on your analysis.
One could see that there would be a compelling case for, as certainly Lord Hoffman and in particular Lady Hale recognised in Adams.
He might not reasonably have expected to acquire the information quickly if in fact he's got such terrible brain damage that it's taking him time to...
Yes. Obviously one's assuming the claimant had capacity. If there's no capacity, then there would be
No, got capacity, that's why I say it takes time.
Takes time.
It has to have lots of meetings and things explained slowly.
And we're drawing you into this, even though, as you say, this is not this case, so it doesn't perhaps matter. But just so I'm clear, is that possibility tied to the alleged negligence having caused the damage, or would it apply regardless, so that you have the person already in this state when the alleged negligence occurs?
It applies regardless.
Yes,
because it's discoverability. And it's the fair opportunity for someone in the claimant's circumstances. And the point of that is that, and this goes back to the triangulation of interest that claimants and defendants and the need for certainty in limitation, is that, well, if you had a fair opportunity, you may not have taken it. You may, like the claimant in Forbes, have thought, well, it's probably just one of those things. I expect the doctor did his best. You may have been under financial difficulty, and there's your own calculus as to where your interests lie. You choose not to. Instead of spending money on paying for your son's petrol, which is something that the appellant did, you save that money and you pay for some legal advice. Well, you may not have done that because it didn't seem as if that was the way in which your best interests lay. But what has the statute done for you? It has given you a fair opportunity. And that fairness, in my submission, is what the statute is aiming at. And the fairness has to be, it's so that a claimant, as it were, perhaps a philosophically minded claimant subsequently, who didn't take action, couldn't reasonably say, I did not have a fair opportunity. You did have an opportunity. And the point of the slight gradation to the test, which, as to whether the claimant can actually acquire knowledge because of some inhibition that that individual claimant might have, is that that caters for that situation too. So, my lords, coming lastly to the proviso, just while we look at the wording of the section, shall be taken by virtue of this subsection to have knowledge of a fact ascertainable only with the help of expert advice, so long as he's taken all reasonable steps to obtain and where appropriate to act on that advice. Well, it's clearly something which the claimant has to demonstrate. All reasonable steps. To bring yourself within the proviso, you have to show you've taken all reasonable steps, and it's a high burden, in the sense that all reasonable steps. Now, what that may be in the circumstances of any individual case is a factual question in our submission. So, if you suffer an injury and you go to a neurologist, and the neurologist says, well, I'm not sure about this, but I think you really need to go and see a psychiatrist. Obviously, you need to go and see a psychiatrist. If you go and see a solicitor, a lawyer, in a case of, as it were, legal malpractice, you go and see a lawyer, then you have to look carefully at who the lawyer is, what the context is, what the advice is. And how does that leave you as a claimant? And looking at the position objectively, because again, it's an objective question, was it reasonable to stop there? So, anticipating my submissions on this, so your lordships know where I'm going, we don't quarrel for a moment with the appellant going back to my client to seek advice in relation to the possibility of setting aside the settlement. There's nothing wrong with that. It's a perfectly sensible thing to do. However, that's not the end of the question. Because then the question becomes, well, was it reasonable to stop there? When you know, when you're told, there is, and it's correct advice, there is nothing you can do to revisit this settlement. Our submission is, well, you've got an unfair and inequitable settlement. That's hurting you at that stage. You're told there's nothing you can do by way of revisiting the position between yourself and your former husband. If you're ever going to investigate the possibility your lawyer got it wrong, that is the moment.
I mean, obviously, spinning that differently, you say, well, look, had the lawyer thought that there was a question of professional negligence, they would have told me that I should seek independent advice. They didn't. That means that a conscientious lawyer doesn't think there's a possibility of reasonable negligence. So I leave it there.
Well, I mean, there is that point, but there's not much weight in it, in our submission, because the position hasn't been addressed by the claimant. I mean, the position is, the possibility is not something mysterious or esoteric. That is something which needs to be asked. It may not be an easy question, but it needs to be asked. And again, the flavour of the case, the facts of the case are important, as the excursion through the particulars of the claim demonstrates in our submission. It is a case where the claimant knows different provision was possible, of different kinds. She knows there was a difficult choice. There was a difficult choice. Do you press on in difficult circumstances, use what little money you've got left, borrow from your parents, which is what the appellant says she would have done? Do you do that in order to explore, investigate, to try and find assets which will give you more favourable provision? Or do you say, draw stumps on the basis, well, the odds don't look particularly good, it's going to be very expensive, and on balance it doesn't look as if it's going to put you in a better position? Well, that's the factual context for this moment when the claimant goes back to the solicitor in 2008, 2009, when she leaves the, as it metaphorically as it were, the solicitor's office at the end of that encounter, told there's nothing we can do to set aside the settlement, she's got an unfair and inadequate settlement. She believes assets have been concealed. She's confronted with her husband driving around with a Porsche and a new business and so forth. And is it reasonable to stop there?
It's tricky, isn't it? Because the very fact that it was also problematic, were you to get to a trial, would help you to say, look, there was no negligence here. This is a perfectly sensible thing to say to this person in the difficult circumstances in which she found herself.
Yes.
But the very fact that it might be possible to say that at a trial might make one think, there was nothing to alert her to the fact that there was negligence. It was, on the face of it, plausible advice.
Well, I accept that. I mean, obviously the limitation issue proceeds on the basis that one assumes that there's merit in the claim, perhaps a disadvantage of a preliminary issue. But what is certainly the case, and there is an element of this in the judge's findings about deliberate concealment, no one, I think, is suggesting, and certainly the judge didn't find, I think he repudiated the proposition, that this was a case in which there was an obvious problem, as it were, where the solicitor had a duty to alert the client that they should seek independent advice. So if one looks at some of the cases, and I'm rather getting ahead of myself, but if one looks at the Godstone case, where the property is wrapped up in trust, and the essential negligence is the failure to put a restriction on the land registry title, preventing a dealing in that property, when the claimants go back to the solicitor, it is obvious, or should be obvious, that the elemental protection for the property to prevent it being alienated in that way has not been put in place. And so it's hardly surprising that the court is going to say, well, you reasonably trusted the advice that you're given by the solicitor at that stage. Or in the Morris case was, I will come back to this in more detail if time permits, the Morris case was where there was an earn-out provision in a commercial sale of a business, and the selling individual had the opportunity to earn money working in the business for a certain period, and then there was the potential to renew that period for a further period.
Can I go back? You accepted that it was reasonable for her to go back to the sisters and say, can I set the settlement aside? To which the one says, no, I'm afraid you can't. And you said, the question is, was it necessary to go further? What is it that you say the appellant should have asked? Should she have said, why not? Whose fault is it that I can't do anything? Or why can't I do anything? What are you saying she should have asked?
Well, there are two possibilities. One is that she takes it up with the solicitor.
Takes what up?
Well, look at the position I'm in.
Mm-hmm.
This surely can't be right. You can't actually have pressed all the buttons that needed to be pressed. That's a possibility, in which event, no doubt, the solicitor would have said, well, I can't address those questions. You'll have to go off and see a new solicitor. The further possibility, and the much more plausible and realistic one in my submission, is that after some time to consider her position, and it does take time to work things through, and one doesn't underestimate the challenges that the appellant was facing, of course. After some time, one has to say to oneself, look, I've got a disastrous outcome. I've got an unfair and inequitable settlement. And it only gets worse. And there's only one possibility. Either, as it were, fate had this, I was doomed from the start, or something different could have been done by the professional advisor who I pay to protect my interests and to get a reasonable settlement for me.
So she should have asked at some stage, is there anything else you should have told me to do, or you should have done?
That's a possibility. Or more plausibly, and the one I would, as it were, pin my colours to, is the slightly different proposition. She should go to new solicitors.
Well, the question which the judge identifies that she ought to have asked is the broad one. This is paragraph 145. How is it that with the supposed benefit of legal advice, I've found myself in this position?
Well, yes.
Do you put it like that, or do you put it in a
I
narrower or broader way?
I do believe that. I suggest the judge was right in that that characterisation, and I suggest it's just like the Forbes case in that respect. And we've looked at the Forbes case, and we can go back and look at it again. Well, perhaps we could look at that, my lords. We just touched on that. We can pick that up. It starts at page 31 in the authorities bundle. And it is a section 14 case, a medical negligence case, but it is a case that was approved of in Adams, and it is good law in our submission. And the central facts were relatively straightforward, as one can see from the head note. The claimant had an amputation following 2 unsuccessful bypass operations performed on it at the defendant's hospital. There was then some time before he received medical advice that the amputation was attributable to an omission to perform the second bypass operation earlier, and then he commenced an action. So the real question was, did he have constructive knowledge within a reasonable time of the bad result? The amputation which had followed 2 successive unsuccessful bypass operations, which took place in 1982. And if we could pick that up at page, in the judgment of Lord Justice Stuart Smith, at page 40. Just so your lordships know where the judgment was going at this point, what Lord Justice Stuart Smith had done was to, in fact, reject the argument that the claimant had actual knowledge at that stage, in other words, in the aftermath of the unsuccessful operations. And the critical reason for that was that he didn't know enough about the nature of the omissions, acts or omissions alleged to constitute negligence. So at the bottom of page 411 of the report, page 40 of the bundle, the actual knowledge finding of the judge was upheld in the Court of Appeal. But that brought on to constructive knowledge. Picking it up at 412 at D, it's clear that deceased could reasonably have been expected to acquire the relevant knowledge with the help of suitable medical advice. The real question is whether it was reasonable for him to seek that advice. If it was, he took no steps at all to do so. One of the problems with the language of section 14.3b is that 2 alternative courses of action may be perfectly reasonable. It may be perfectly reasonable for a person who's not cured when he hoped to be to say, oh, well, it's just one of those things. I expect the doctors did their best. Alternatively, the explanation for the lack of success may be due to want of care on the part of those in whose charge he was, in which case it would be perfectly reasonable to take a second opinion. I don't think the person who adopts the first alternative can necessarily be said to be acting unreasonably, but he's in effect making a choice, either consciously by deciding to do nothing or unconsciously by in fact doing nothing. Can a person who's effectively made this choice many years later, without any alteration of circumstances, change his mind and then seek advice which reveals that all along he had a claim? I think not. It seems to me that whereas here the deceased expected or at least hopes that the operation would be successful, and it manifestly was not, with the result he sustained a major injury, a reasonable man of moderate intelligence, such as the deceased, if he thought about the matter, would say that the lack of success was either just one of those things, the risk of the operation, or something may have gone wrong, and there may have been a want of care. I don't know which, but if I'm ever to make a claim, I must find out. In my judgment, any other construction would make the act unworkable, so the plaintiff could delay indefinitely before seeking expert advice and say, as the deceased did in this case, I had no occasion to seek it earlier. He therefore would be able, as of right, to bring the action no matter how many years it elapsed. That's contrary to the whole purpose of the Act, which is to prevent defendants being vexed by stale claims, which is no longer possible to contest. I mean, that may, with all respect, have been slightly overstating what the purpose of the Act was, because I accept that there are different interests in the play, not just the defendant's interest, but the defendant's interest is important nevertheless. And so, my lords, those observations of the submission fit very happily, we would suggest, with the facts of this case. There is a bad result. It's brought to home to the claimant, to the appellant, how bad it is within a year or two of the settlement. And you have a choice. I mean, do you move on with your life? And that's what the appellant said in cross-examination she did. Do you move on with your life, or do you question it? How did I end up in this situation?
Those do fit with the facts of this case, but they go to the discoverability question, which is the one that Mr. Hall concedes. So you've got over that hurdle. They don't address the proviso, where really it seems the question comes down to whether the claimant had taken all reasonable steps. And you say, as I understand it, that she hadn't, because even faced with the advice that there's nothing she could do to reopen the settlement, she ought to have gone further and either raised it with the same solicitors or with different solicitors. How come I find myself in this position? And Mr. Hall says, no, because she can effectively rely on the fact that if there had been any negligence, then the solicitors would have told her to get independent advice. That seems to me to be where the quite narrow issue has come down to.
Well, I see that, but I would say that there's as it were, an additional arrow in the quiver here for my client, because if this is a Forbes case, the significance of this passage is that the hypothetical reasonable person in the defendant's position would investigate directly the question of the potential deficient advice of the solicitors. So there are two ways of getting to the same end. One is to, as it were, just look at what the appellant actually did. She went back to the solicitors to ask about a different question, whether she can set aside the settlement. And she's told she can't. And I say, well, if you're looking at the proviso, you haven't exhausted what you need to do to bring yourself in the proviso. But I say that it goes further than that. And in my submission, the judge effectively accepted this submission. That in any event, this appellant, left in the situation in which she was left at that stage, acting reasonably, would seek advice on the targeted question, if I can put it that way, of whether her solicitors have advised her properly or not. Did they serve me well? And again, it's effectively a factual question on the individual case, but our submission is on the facts that there was an obligation to address that question directly in the same way that there was for Mr. Forbes. It may have taken a little bit of time. He's got to come out of hospital. He's got to think about his position. He's got to reflect upon it. I accept all of that. So, I mean, one feature of constructive knowledge, as your audience will appreciate, is it may take back the starting point in time. And that may be significant in some cases, not in this case.
Yeah, and that's what the judge really says at 145 to 149. So he doesn't say she should have asked the solicitors, how is it I'm in this position? She should have asked herself that question.
Yes.
And realising that, he goes on to say, 148, what do you say about Forbes? It's one of the things she's got to do. Is she going to accept it or investigate it? And then at the end of 149, she knew enough for her to begin investigating whether or not the firm was at fault, which does look like a 1410A, 14A10 question. But that's what he was saying, I think, then.
Well, yes. I mean, certainly that's the way we put it. I mean, there are two different routes to the same end, perhaps, but certainly that's the primary way it was argued at trial, from my recollection, and that is the primary way I would put it.
Sorry, so can I be clear? What was the primary way argued at trial?
It wasn't so much in this respect, my lord, the focus upon, certainly from my client's perspective, on whether the claimant had acted reasonably in going back to the solicitors to seek initial advice. The focus was on the Forbes point, that knowing what you know, you should inquire further directly about the potential deficiency of the solicitor's advice. Had you been served well by your professional advisor?
She either raises it with them or she begins to doubt them and goes off somewhere else.
Either way, she would get to somebody who could tell her what she needed to know.
And this is all in the context of subsection 10?
Yes, it must be.
Yes. Yes, in the sense that I accept that certainly in constructive knowledge territory, she needs to go to an expert.
And indeed, in Forbes, as you were stressing a moment ago, there was no finding of actual knowledge.
Yeah, quite.
Therefore, it has to be subsection 2.
Yeah. And the facts of Forbes are quite interesting. I mean, it was just, I forget precisely, but it was just advantageous circumstances which eventually led the claimant, and that sometimes happens. Same with some, I mean, I think in one of the other cases we've got here, the case at Schumann, the authority at page 143. This was the clinical negligence case, which was abandoned, I think, before proceedings were served, and eventually the claimant brings a claim against her solicitors and barrister. And I think it was only in the context of subsequent divorce proceedings that someone said to them, well, you know, I'm not actually sure that you've got proper advice from your lawyers about the abandonment of that claim. So, I mean, in this case, you know, it was entirely unforeseeable, adventitious that the appellant ended up in a relationship with a solicitor, conversations took place, and there became a focus on the possibility that the settlement had not been fair and reasonable, that there might have been assets that were concealed and so forth. And so that the situation developed in a way that your lordships know about. And nothing otherwise changed. So, I mean, the consequence of saying that there isn't at least constructive knowledge back in 2008, 2009, is that, you know, someone in the position of the claimant has it, whereas until the long stop bites, has got an infinite opportunity to, depending upon the vagaries of events, bring a claim at a later stage. And we submit that's not fair to the defendants, that at that point the balance is tilted too far. Because you've had your fair opportunity. There may be understandable reasons why you didn't take it. Just as I mean, no one would morally blame Mr. Forbes. I'm not casting any criticism towards the appellant for the fact she didn't take this action, in a sense of you know, any criticism beyond the artificial legal criticism that I make. But,
And of course, in the circumstances of this case, there isn't so much difference between these limitation periods and the long stop. I mean, there is a long stop.
There is. There is, and so that obviously prevents it going on ad infinitum. But it doesn't mean that therefore, contrary to any suggestion at one point in Lady Hale's question in Adams, it doesn't mean that one should, as it were, be generous to claimants about this, because there's still the interests of both parties to take account of.
I mean, one of the oddities in this sort of area, and this is going off on a red herring for a moment, is in the context of section 14, they say, well, there's section 33, so there's no need to adopt a particular sort of construction. Then you use the same wording in section 14A, where there is no section 33.
Yes.
Anyway, there we are.
My lord, in fact, just to add to the burden on your lordships, I handed up two pieces of paper. I don't know if your lordships have them. I wonder if we could just have a quick look at those. One of them is section 33. And if we could look just at section 33 first, and I imagine a provision that's familiar to the... it's of some interest, the way in which, where different interests are in play, and obviously personal injury is much more, an interest the law is much more concerned to protect. It's some interest the way in which Parliament goes about dealing with the statutory discretion, effectively to relieve from hardship, where the balance of justice will allow a discretionary extension to the limitation period. One of the ways it does that is to identify particular considerations which feed into the statutory discretion. One can see that on at subparagraph 3 on the third page of the extract. It's the broadest possible discretion. So all the circumstances of the case. And critically, the length of and the reasons for the delay on the part of the plaintiff.
And the conduct of the defendant after the cause of action arose.
Indeed, my lord, but particularly that phrase, the reasons for the delay. I mean, that allows a focus, as it were, on the lived experience of the individual claimant. You know, looking at it from the claimant's perspective is a factor to weigh. In slight contrast with that, subparagraph E, the extent to which the plaintiff acted promptly and reasonably, which in my submission is clearly a more objective approach, an objective approach. So when Parliament wants to afford space, forensic space for an examination of why the individual claimant did not act in accordance with the standard of a reasonably diligent and inquiring claimant, then it can do so. And that's conspicuously absent from section 14A. And that obviously just reflects the different balance of interest that the section 14A and section 33 are dealing with. And I'm not going to refer your lordships to it unless your lordships want to see it, but just that your lordships have the Law Reform Committee report in the fundamental authorities, which emphasises these two concepts of discovery and discoverability, and also the need for certainty. So a fair opportunity for claimants, being fair to defendants too, not exposing them unnecessarily to stale claims, and certainty. And certainty is important. I mean, the number of limitation cases may make one think that that's more of an aspiration than an achievement, but it is important, and it's a relevant consideration in my submission when thinking about how the statute should sensibly work. And the difficulty with personal circumstances, for instance, the difficulty with means, is that cases become less easy to deal with, they become much less certain. How are you going to predict the result? What evidence are you going to see on disclosure about means? What are the witness statements going to say?
And indeed, what could you do in your impoverished circumstances? What alternative courses would have been open to you to obtain advice or help?
Can you get a job?
Or indeed, can you go to Citizens Advice Bureau? Can you go to some other way of getting free legal advice?
Pro bono scheme, whatever it is.
Yeah.
Internet nowadays. Or possibly not artificial intelligence. But
Not in 2008, anyway.
not 2008. Statements. For want of a horseshoe, the battle was lost type. That is what one will get. Difficult inquiries as to whether impecuniosity over time, and it may be a very long period, 10, 12, up to 15 years, insofar as there is financial difficulty, which in itself can be a difficult question, was that occasioned or plausibly occasioned by wrongdoing? So in this case, for instance, when the house was sold, there was, as I understand it, £100,000 thereabouts of capital that was released from the sale, and the claimant and her children went into rented accommodation. There is an indication, perhaps we could just have a look at the document, that was lost because of the same fraudster who took money from... Yes, I'm just finding the document, forgive me.
Isn't this all a bit irrelevant? Because the ultimate question is whether, by seeking the advice which she did seek from Mrs. Mary Kay, the claimant had taken all reasonable steps. And if she had, then she can rely on the proviso, and she's got 15 years, the long stop. And if she hadn't, well, time has started to run.
Well, I mean, the slightly different features that I would respectfully suggest at the two different periods. I mean, 2008, 2009, that is certainly a highly material question.
I mean, it's the question, isn't it?
Well, save that there may be two routes, as it were, to the answer I'm asking the court to find. One is focusing upon whether the moment when she leaves Mary Kay's office, and the other is focusing on the moment when, as in Forbes, there's a moment of reflection about the situation in which the claimant finds herself more generally, and whether there is not here a good reason to question whether the plight that she faces is due to deficient advice.
So in a sort of way, we are moving on to the later period, but before we do go on to the later period, we've explored subsection 10, and you've set out your stall on that.
Yes.
But you're running actual knowledge as well.
Yes.
What more is there to say about actual knowledge in relation to the earlier period?
Well, I can deal with that now. I was going to,
No, in that
I was
case,
going to finish with principle, as it were. I've
Yeah, no,
rather
no, in that
straying
case-
into facts.
sorry, in that
I
case,
haven't
do
maintained
that.
a clear-
You've been led by us into talking about particular features of this case, but
Yes.
no, stay with principle.
I will,
Can I just ask one question though?
yes,
On impecuniosity in the earlier period,
yes.
if what was a reasonable step would be either at the time or after a period of reflection to seek other advice from somebody other than the respondent, does impecuniosity arise in relation to that period on the evidence? Was it said that even in 2008, 2009, she simply couldn't have afforded a solicitor or a barrister? Or have we just not seen any evidence about that?
I mean, certainly I think it's fair to say that the general drift of the appellant's position was that she was in difficult circumstances throughout. So I don't dispute that, I'm sure her statement will say something to this effect, and that was our understanding at trial. But the difficulty the claimant has, and our submission the appellant has, is that she has got to prove that impecuniosity prevented her getting advice.
Because in 2008,
If it's
2009,
relevant.
she's got the reduced sum of money from the house,
Yes.
less because of the financial collapse. And she's not bought a new house, she's gone into rented accommodation. So there is a capital sum available. I don't know whether we know or whether we know enough
Yes.
about whether in the 2008 and 2009 period, if she really thought that things should have been done differently and she was wrongly advised, could she have used some of that sum? And
Well,
would it have been reasonable for her to do
There are
so?
two different things, my lord. I mean, one is that her pleaded case is that her parents had money, could have advanced her money,
Yeah.
and then they sold a property. So they had funds, but by the end of 2009, by the end of the year, and it went very quickly, a gentleman, Mr. Zumby, I think his name was, had taken that money, had defrauded them
Yeah,
of that.
but that's from the sale of their
That's
house.
the same with their house. She retains her own property until a little bit later, until 2011,
Oh, so the Wall House wasn't sold until 2011, was it?
Manor Cottage.
Oh, she was in Manor Cottage.
Manor
Wall
Cottage.
House is the other one that was renovated.
So 2011, she sells Manor Cottage for £477,000, and that realises £100,000.
Right.
I thought, perhaps I've got this wrong, that Claimant's case in 2008-9 was not that I couldn't have afforded to take legal advice, but that I didn't need to because I'd done all I needed to do by going back to the same solicitors, and that the specific plea of impecuniosity relates to the later period. Am I wrong about that?
No, that is correct. That is correct. But I was really perhaps being drawn by my.
I mean, I appreciate she was always saying I'm in difficult
She was.
circumstances.
I didn't
but
want to
not,
misrepresent the facts.
but not to the extent of saying I could not have got legal advice if I knew I needed to go somewhere else in 2008.
That wasn't the way it was put. I think that's fair.
So did you put it that she should have gone to someone else after a period of reflection in 2008, 2009?
I did, I believe. Yes.
Right.
And,
That was part of your case then?
yes, it was. Yes. Because it was very much Forbes' intention.
Yes, it must have been because he refers to Forbes in 144 and onwards. Yeah, okay.
So, Maud, can I just finish with principle? I thought we ought to just alert your lordships to the other piece of paper that was handed out, which is the ADCAM case. Neither of us think it actually takes the present debate any further, but it is a decision of the Court of Appeal as recently as the 6th of February. Your lordships may know of it already, but this was to do with Section 35 of the Limitation Act. And the only reason I mention it is that at 2 points there is some very compressed reflection upon the way in which limitation acts ought to be approached by the court. The first passage comes at paragraph 64 in the judgment of Lord Justice Saccaroli. And he makes the point that it's important to keep in mind that the Act is intended to strike a balance between a hardship to a claimant and being prevented from pursuing a good cause of action to which there may be no defence, and the hardship to a defendant having a cause of action hanging over him for an indefinite period. Each provision of the 1980 Act represents Parliament's attempt to strike a balance between those irreconcilable but legitimate interests, and then a reference to the Haywood case. As Mr. Carpenter stressed, Section 35 provides for amendment outside the limitation period in specified circumstances only. The question for the court in any given case is whether it falls within those circumstances or not. There's no general discretion to do justice. And a similar passage, my lords, at paragraph 103 and 4 in the judgment of Lord Justice Singh. We're picking it up from the second sentence in paragraph 103. A particular remark of Mr. Justice Leggett, as he was disapproved of, and the reasoning, one reason for this is overlooks the important but fundamental starting point that Parliament has chosen to give the defendant a statutory defence by reason of the passage of time in the Limitation Act. C. Haywood, Lord Scott, task of the judiciary to identify from the statutory language and the purpose of each amending enactment the balance that the enactment has endeavoured to strike and to apply the enactment accordingly. It's emphatically not the function of the judges to try to strike their own balance, whether as a response to the apparent merits of a particular case or otherwise. No general discretion to waive what would otherwise be the impact of the Act. So, my lords, obviously, maybe I'm not sure it's straightforward as it were, but we say that's entirely consistent with the approach to construction, which we invite the law to take. So, my lords, I think I have addressed the main features of the Act and what we say actual knowledge is, and the need to be put on inquiry. Constructive knowledge, the cases are dealt with in my skeleton. It's the Forbes point in particular that I rely upon, or there are some other cases which are to a similar effect, which are in the skeleton. Just checking I've dealt with these points. Then there's the question of means, whether in principle that is something that one should have regard to. I say no, and a passage from Lord Scott's judgment in Adams, paragraph 73, which my learned friend took your lordships to yesterday. In my submission, is if one's looking for an encapsulation of the position, Lord Scott at paragraph 73 in Adams said, what would a reasonable person placed in the situation in which the claimant was placed have said or done? And that, in my submission, is a helpful distillation, a helpful formulation of exactly what the question is.
So this is the stage at which we're going to discuss the significance or otherwise of impecuniosity.
Yes.
Yeah. I mean, there's an ambiguity in that. What would a reasonable person placed in the situation in which the claimant was placed have said or done? Well, is this a reasonable person placed in the impecunious situation in which the claimant was placed?
Well, I see your lordship's point, of course, but we say the answer to that is no. And it goes back to what the subsection is dealing with, what you actually know or what was discoverable.
What you could reasonably have discovered.
What reasonably?
If you didn't have any money, how could you reasonably discover it, is the question.
It's the starting point. It's trite, but it's an important observation in our submission. But we're talking about a starting point. You've got 3 years. No one's suggesting it's necessarily going to be easy. But there are no shortage of lawyers. There are no shortage of lawyers, some of them anyway, are prepared to work on a pro bono basis. There are ways in which one can get advice. That is long enough to get a job and to save some money to get some advice. So, in thinking of whether you've got a fair opportunity, I mean, I'm taking the hard cases away.
Well, you keep saying fair opportunity. You rewrite what Parliament has said. It's which is reasonable for him to see.
Yes. Indeed, my lords. But as it were, if one thinks about the consequences of a construction which says, well, your means are on the wrong side of the line, that's not something which the court should have regard to, even if it's plausible to suppose that the defendant has caused that problem. So I'm as it were, taking the hard case to test the case the submission.
Can I take a silly example just to sort of set the outer limit? At the stage where you could otherwise do something, you go on holiday in a country in which you are then imprisoned most unfairly and deprived with all contact with the outside world, so that for the whole of the period you can't do anything. Now that's something personal to you, it's not something that would apply to everybody in a similar situation, but presumably you can take that into account.
I would say no. I would say no, because, I mean, you know, obviously the, no, I say no, because the, one's looking at what the claimant knows. So before going on that holiday, one obviously wouldn't even get into constructive knowledge unless there was some appreciation of a potential problem. But then, if circumstances entirely reasonably mean that you can't progress your inquiries, then
you read the Foreign Office website and it says Ruritania is a marvellous country with a wonderful climate. So you book a flight to Ruritania. You arrive, a coup having taken place 6 months earlier by the anti-British faction, who seized you from Wales, and they put you in prison, and you can't get out for 14 and a half years. Can't you take that into account? I'm giving an absurd example. Say that, you know, there are times when you've got there because the Foreign Office has told you it's lovely.
No, I see the point, my Lord, but
yeah, you just say no.
No, and it's because you're. I mean, this is the balance of interests, and there is a defendant's interest in play as well. So if the time is ticking, if there's the obligation to act, and you've got to get to, you know, you've got to be at first base as well. Otherwise, obviously, you're not in constructive knowledge at all. So you've got to be at the moment where you ought to be investigating. But then time runs. It's about the start of the running of time. And there are many circumstances in the Limitation Act, as you all should know, where time runs and there will be all sorts of difficulties that many claimants will face in some cases. And unfortunately, that does not come to their assistance. The only provision, the only provision is Section 33, because of the particular protection that, well, Section 33, reasons for the delay. The lived experience, that can weigh into the equation. I suppose, in a sense, Section 32 could, with reasonable diligence, have discovered all the elements of the fraud that you need to plead for the set up a case in fraud, something of that sort. So you can see a greater degree of protection in different ways that those sections might import. But it's not a perfect solution. A perfect solution of some, you know, one of the possibilities was the discretion when the Law Reform Committee was looking at this. That was a possibility. The Parliament didn't go down that road. So you're seeing things through the prism of discovery and discoverability, and that's what starts your 3-year period.
I don't see why you seem to be saying that the words the Parliament has chosen precludes the Ruritania example, but it says for the purpose of this section, a person's knowledge includes knowledge which he, that person, might reasonably have been expected to acquire. That does seem to be looking at that person, and could that person have acquired it?
Well,
or reasonably have been expected to acquire it?
Yes, I mean, in the relevant circumstances are the circumstances pertinent to the claim. So circumstances of a unforeseeable, different, unpredictable character, which have nothing to do with the, as it were, the mise en scène of the potential action, those are beside the point in our submission. And one of the consequences of this, if this submission is accepted, is that there is a consistency between different claimants. And it's not unusual, as you all should know, for there to be many different claimants bringing effectively the same claim, a group action or whatever. The consequence of allowing consideration of individual circumstances, the way the claimant is placed, of the sort that the Ruritania example highlights is that you get different limitation periods. You get limitations starting at different points according to matters of which the defendant could never be expected to have any knowledge. And that, in our submission, is not what the Act is seeking to do. It's a compromise, and it's it's tough for defendants in the sense that someone gets more than 6 years where it applies. It's tough for some claimants if the circumstances are such that they have actually, well, constructively knowledge of the particular facts which trigger time running, but their individual circumstances, whatever they may be, make it very difficult for them to progress inquiries. So there is a as it were, there is a grant of favour, but there's also a withholding of favour in this respect, and that is the compromise. That's it's seeing everything through the prism of knowledge, actual, constructive, and producing a sensible, somewhat hard-edged in some cases, I accept, but a sensible compromise of interests.
And of course, I mean, thinking of things that might sort of fit with that thesis, there must be lots of potential claimants who think they have quite plausible claims against people, but who think, I've got money to get the advice, but I'm not going to risk the costs of the legal proceedings. In one sense, it's impecuniosity, but limitation will still bite on them.
Yeah. And again, you've got your 3 years. So even in very difficult circumstances, so far as impecuniosity is concerned, there is an opportunity. One would anticipate that, the drumbeat underlying all of this is the active and vigilant claimant. The law assists the vigilant. So claimants who fit that mould, even if they are impecunious, have 3 years. So whether it's saving gradually, whether it's getting a job, whether it's seeking free legal advice, in our submission, in most cases, there may be exceptional cases, in most cases, that will afford a fair opportunity, which is why, again, one can suppose the philosophically minded claimant could later on stand back if they didn't take action and think to themselves, well, do you know what? I did have an opportunity. There are reasons why I didn't take it, but I had an opportunity.
So the other thing is, if you are going to look at impecuniosity during a relevant period, you're going to have to do it quite carefully, because you're going to have to see what money they've got and what they could have saved. Did they have a holiday, or could they have ditched the Netflix subscriptions? And you'd have to do that to see. And the question then is whether Parliament expected that exercise to have been undertaken. And sometimes things might go wrong. I mean, somebody might have had money, but for the fact that the builders went insolvent and the housing market fell, things could change. So it might have been not impecunious on one day, but things go hard later.
Or just the vicissitudes of life.
Yes.
Money's taken by a fraudster. The action against the builders. They went insolvent. It was expected to produce £75,000. It produced nothing. So an asset that the settlement was designed to confer, and in a sense did confer, because the benefit of the cause of action was the claimant, but it delivered nothing.
Or you might just decide to prioritise other things. You may say, no, I'd actually prefer my children to have a particular type of education, or the opportunity to go on a school educational trip. And you'd have to investigate all of those, I suppose, would you?
You would, yes, because you need to be demonstrating not just the state of your finances, but it was that which was the obstacle. And I'm anticipating, but the evidence doesn't come anywhere near demonstrating that in this case.
That's a separate question.
The evidence demonstrates the claimant was in difficult financial circumstances at all times. Personally, it doesn't demonstrate that it was not possible to, one way or another, to get assistance. Similar, I was going to come on to the Whitcomb case, whether this is a Whitcomb decision. And although Whitcomb's one of the interesting cases which offers some general propositions of general application, but its facts are very unusual in our submission. And I just wanted to take your lordships back to the facts to make that submission good. And if we could go to the first instance report, starting at page 182 of the authorities bundle. and the claimant obviously had a serious leg and foot injury in a road traffic accident in 2002, and there was a settlement after advice from solicitors and counsel on a full and final basis for £150,000 in 2009. Now, what's important in the case, in our submission, is to appreciate the nature of the advice that the claimant had received before settling. And one can see that in this first instance decision, starting at page 187 of the bundle, at paragraph 19. And 27th of November 2008, the solicitor writes a letter, an offer of settlement has been received, it's once and for all, you won't be able to obtain further damages arising from the accident following settlement of the claim. You haven't made a full recovery. At least one further operation is required. It's not anticipated that the operation will take place prior to the deadline for the offer. If you settle your claim prior to the operation is not a success. There's a risk that you will have settled your claim at an undervalue.
Sorry, where are you reading from?
Sorry, it's paragraph 19, my lord. So it's on page 187 of the.
Yeah, I see. Yes, I see. Yeah.
And as we follow through the chronology, the similar message. Paragraph 20, solicitors view the claim wasn't capable of quantification at that time, it's not safe to settle. Paragraph 21, reiteration of that advice, and if we look through to the end of the quote, you appreciate why we've advised it's not safe to quantify and settle your claim at the present time. You appreciate the settlement is a once and for all basis, and therefore, if, for example, the operation doesn't proceed in a satisfactory manner, you will not be entitled to seek further compensation from the defendants. Unlikely the court would stay the claim, paragraph 22, pending the operation. So they have a settlement meeting and telephone conference, and the claimant confirmed he understood a settlement would be full and final, and he was warned not to feel pressurised to settle just to get the litigation over with. Then the file note of that meeting at paragraph 25, and if we can look over to the next page at Roman numeral 5, he was advised that settlement was being offered on a once and for all basis. So if after surgery to remove metal work, it was discovered that he had a more serious injury than was previously appreciated, he cannot recover further damages. Also, if you can go from that passage, please, to...
Well, was it a case where the defendants, i.e. the original defendants, admitted liability, or was that an issue?
No, that was an issue.
So he might have got nothing.
Oh, I forgive me, the original defendants, in the road traffic accident case, I can't recall, my lord, I'm afraid.
Oh, no, it does say in the head note they admitted, in due course admitted liability.
Oh, I'm sorry, thank you.
Yeah.
Yes, thank you. If I may, just while dealing with, as it were, the salient character of the facts, move on to how the judge characterised the position. If we can look at page 198 of the bundle, paragraphs 82 and 83. On the 16th December 2009, on the date of, at or about the date of settlement, although he knew about the risk of undersettlement, the claimant had absolutely no reason to suspect the risk was caused by anything done or not done by his advisors. On the contrary, those very advisors expressly advised him that the risk existed, reminded him to decide for himself whether it was a risk he was willing to run. On the basis of the advice given, he may have felt critical of the legal system for not providing any alternative solution, but that was not a reason to suspect it was his advisors who were depriving him of that solution. He had no reason to suspect that there had been flawed advice or flawed omissions from the advice before 2017. When his condition worsened in 2015 and 16, he was experiencing precisely the kind of post-operative problems which his advisors themselves had referred to in 2009 when they identified the risk of undersettlement. That was not a reason to consider that he might have been wrongly advised. So, my lords, that is the essential factual context for Whitcomb. And we can see that's picked up in the Court of Appeal, and at one point in the Court of Appeal it suggested, well, the claimant was in the position of a claimant before the Supreme Court Act was amended to allow for provisional damages, in the days when you couldn't do anything about the risk that you might develop a deterioration in your condition or some defined disease, which might give you a right to return to court for further damages. Whitcomb, the judge's findings upheld in the Court of Appeal, the claimant had been told there was a risk, he would get worse, and there would be no opportunities to come back to court. His experience in the succeeding years was the very risk of which he had been warned eventuated. Now, that's quite an unusual fact pattern in our submission, and it's certainly not the fact pattern in the present case. The fact pattern in the present case is very different. It is a claimant who settles, making a difficult choice to draw stumps when she's under some financial pressure, when she knows the alternative is to spend money on further investigations, when she knows that it is possible for the court to make different provision in terms of ongoing maintenance, in terms of capital provision, in terms of setting aside a property disposition, in terms of pension provision.
So is this not a section 1710A, 14A10 case, it's a 6.8 case, because there was no further facts for him to discover. The facts were everything that he knew, and the only thing left was the legal thing. Was it negligence not to tell him?
The judge found, and I recollection there's no appeal on this particular point, the judge found that he knew damage. He knew he'd suffered damage when his condition got worse in about 2016.
Yes, he knew the damage he'd got, and the damage would have been the undervalue of the settlement, the failure to reflect the full loss that he'd suffered as a result of the accident. So he knew that. There weren't any further facts that he needed to get expert advice to help him find out about. So the question is whether or not knowing all that he did at the time, that was enough to give him the knowledge of attribution.
Yes, I mean, my friend murmured, and he's right to murmur, that in fact there was an attempt to appeal on damage. On appeal, the appellant, the defendants in the case, one of the defendants said, well, actually, you knew about the damage from the moment of settlement. But that submission failed. There was no cross-appeal that, in fact, the claimant didn't even know about damage at the date when the judge found that the claimant knew about damage. So the way the position rested after the appeal was that the claimant had known of his damage in about 2016, when his condition got worse, and he realised that the risk he had been told about had eventuated and was hurting him. The real debate was to do with attribution, and in the context of an actual knowledge case. And the reason why we submit the claimant and appellant succeeded at both levels is because on the particular facts in Whitcomb, there is no reason for the claimant to think something has gone wrong, to think he's not on inquiry. Because the very risk he's been told exists and about which nothing can be done is eventuating. So the nature of the solicitor's advice, as it were, covers the position, covers the outturn. And a reasonable claimant in those circumstances would have no reason to suppose that there was a reason to investigate whether his lawyers had acted in a deficient manner.
I'm trying to translate it to the facts of this case, because rightly or wrongly, I can see the argument that this case isn't an actual knowledge case in 2008, 2009. And it is a reasonable acquisition of further knowledge case. And I'm wondering why Whitcomb isn't the same, really.
Yes, well, obviously,
that's the difficulty I have.
I'm very happy with the decision of this court that the judge was right about constructive knowledge in 2009, but he wasn't right about actual knowledge.
I didn't say he was right, so I can see the analysis. Which of it? I'm still trying to understand the questions. I haven't written my exam answers yet.
No, indeed. But obviously I'm riding a number of different horses.
But I don't understand why Whitcomb wasn't constructive knowledge, I think, is the problem.
Yes, well, I mean, as I was one of the defendants in the first instance, I was in
Of course,
I can say about
I mean,
that. But, yes, but it wasn't. I mean, it was just argued as actual knowledge, and I you know, certainly a feature of the forensic landscape, as I mentioned already, is the way in which the Hayward formulation of actual knowledge does actually advance the time. Sometimes you may have an earlier date, paradoxically, if you look at it as an actual knowledge case than as a constructive knowledge case. As a constructive knowledge case, you don't actually get time running until you've got the knowledge which you could reasonably have obtained. So that's the forensic attraction for defendants, I suspect, of dealing with actual knowledge. But coming back to Whitcomb and why this isn't a Whitcomb case. First of all, there's the general point that this is, if you look at the pleading, it's not a case about this is not a case where the claimant is simply coming to court saying, well, I did not have the opportunity to go back to take advantage of a nominal spousal maintenance order. So, on a fair characterisation, it's not in the same genre, I would submit. But secondly, what matters is the factual question. What matters is the factual question. Did you have reason to think that something might have gone wrong? How could this have happened? How could I have been left in this position? And one can understand, enlightened by, as it were, by the judges in Whitcomb, why that claimant was not ever in the position of thinking something had gone wrong. There was a real possibility there was deficient advice, which had caused the problem. Conversely, and we submit, on the facts of this case, it's very different. Because the claimant knows she hasn't had the provision she could have had.
Well, she doesn't know that, does she? I mean, she was told at the time about the possibilities of investigating things, and the advice was nevertheless to do the deal, which she does.
Yeah.
Why is that so different from Whitcomb?
Well, she knows there could have been a maintenance order. She knows there could have been an order for maintenance in her favour. Could have been. The court had power to make it. The court
That
had
would
power
be out of the money that they can prove that he's got. Her problem is he's hidden, or she said he's hidden the money.
Yes, but you know, in Whitcomb, he didn't know about the possibility of a form of award. In this case, if you look at what the claimant is complaining about, I should have had further maintenance, I should have had pension provision, I should have had a more generous capital provision, in part consequent upon a setting aside of a dealing in a valuable property. Well, the claimant knows that that was within the range of the court's armoury. She offers were made. She knows that could have been done. She knows.
I mean, this is a tricky thing because all these points go back to how it would be fought at trial. You say, well, for this purpose, we have to assume that there was negligence. But in another sense, all these things also mean she might say to herself, you know, what reason have I got to think that there was negligence?
Well, if I sort of crystallise it by saying, well, look at the position after the appellant has, as it were, left Mrs. K's office for the last time, when she's been told and it's been reiterated, you can't, there's nothing you can do about this. If it was a Whitcomb case, one would have to be able to point to something factually whereby she was left thinking, well, there was really no alternative but for you to have ended up in the situation in which you have ended up, because there is nothing that could have been done differently. But that's effectively the factual position in Whitcomb in our submission, the distinguishing factual position. In this case, it's very different. The very focus of debate and consideration between solicitor and client is, well, do we draw stumps or not? There are things that could be. There is more generous provision that could be given to you. You could push on to trial in the hope of getting that. You could push on in the hope of getting maintenance and getting a more generous lump sum in investigating. You might be able to show offshore assets and so on. Set aside all house. She knows that could have been done. She knows that. She knows why it wasn't done. It wasn't done because the solicitor made a recommendation. You're going difficult, I'm paraphrasing of course, but difficult financial position. It doesn't look as if it's in your interest to go down that road. We may never be able to demonstrate anything anyway.
Can you analyse it in a different way though? Can you say, consideration of what you can do now, get a bigger maintenance order and so on, was considered but written off because of the cost. But what you wasn't told was there is one other way available that we could keep matters open just in case you ever get the proof that he's got the money in the offshore funds and that it's the family that's taken the house and all the other things. And it's not telling her that she's got one option available, like in Whitcomb, there was one option available that would have allowed her to come back at a later stage if she got the proof at a later stage.
It's not an option in Whitcomb. It's the only form of relief that it was suggested should have been in place. So
I understand that, but why isn't it? I mean, there are different groups of options, if you like, and
yes.
I understand that Whitcomb was a simpler case, but why isn't it enough to say this part of the case, she wasn't advised about the option, which would have allowed her to come back at a later stage? Not the options to do with going now, but with coming back, where she might have better proof. Things might have come to light.
Well, the question is whether the claimant is on inquiry, to use a shorthand. And it's entirely artificial in our submission, when you look at the scope of the pleaded case, to focus just on that question. That's not fair to the defendants. You can't pick one element of your case, not even the primary element. It's in the mix, but it's not even the primary element. You can't pick one element and say, well, because I didn't have any reason to suppose that something had gone wrong in that respect, therefore I wasn't on inquiry, if, for all sorts of other reasons, you're on inquiry. So, if your lordships accept my submission that one's entitled to look more generally at the position, and the only question is whether she's on inquiry. She's on inquiry because there's an unfair and inadequate settlement. She knows there were things that could have been done differently, which potentially would have delivered a better outcome.
But so far, it's like Whitcomb, isn't it?
Well,
because in Whitcomb, there was always the possibility of holding out for more. There was a decision to make as to whether to settle the bird in the hand. Well, bar the NSMO, this was the same.
Well, I mean, the allegation in Whitcomb was, first of all, get a classic surgeon's report. Secondly, on the back of that, plead a case for provisional damages. Identify a specific risk in respect of which you want the opportunity to come back to court if that eventuates.
Presumably in Whitcomb there was not the possibility of holding out for more as matters stood, because if liability had been conceded, then the settlement reached would have represented full value for the injury as they stood, and the only risk was the possibility of deterioration subsequently, which would need that sum to be revisited, which is rather different from our case.
I mean, certainly I don't think it was a case of undersettlement, in the sense of, you settled for too little on the basis of a lump sum settlement. The case is that you didn't have this particular forensic statutory form of damages, which was available to you, which would, on the facts of that case, have enabled the claimant to be protected against the future, specific future risk which should have been identified.
Yeah, and that's the difference. In our case, the claimant could have said, I want you to investigate these things. I want you to hold out for more maintenance, etc. But in Whitcomb, if the claimant didn't know about possible provisional damages, he was being offered everything to which he was entitled.
My lord, I do accept that. And again, coming back to my lord's point, well, why isn't it a Whitcomb case? And the reason is, well, you have to go back to, is the claimant on inquiry? And you have to set that in the factual position that the case involves. And if this was just a case about an NSMO and nothing else, then Whitcomb would apply. Actually, I can see that. But it isn't. And if you put yourself in the factual position, as of course the judge did, then you've got a claimant who knows about different forms of provision, doesn't know about NSMO, but she knows about other forms of provision. She knows they weren't pursued further, but they could have been. She knows there was a decision to be made, and she decided to draw stumps, but she could have taken a different decision.
And I do understand how you put it, but just in terms of the fact that in Whitcomb liability had been accepted, I mean, the solicitor said there's a risk you'll have settled your claim at an undervalue. So he could still have held out for more. He could have waited to see how things turned out medically and potentially got more, but he chose to settle for what was then on offer.
He did. He wasn't keen to go to court. He was anxious to reach settlement. That was a feature of the facts of the case. But nevertheless, I'm conscious I'm repeating myself.
Yes.
But it's a very different case. It's a very narrow focus case on the facts, and that's a very different case to the one that is in question here. And I'd obviously ask for the reasons the judge found, in effect, that in that wide spectrum of complaints that the particulars of claim encompass different forms of damage that are an issue. It's inappropriate to narrow the gaze and look just at NSMO.
Yeah.
One is looking at whether the claimant was on inquiry generally. And in our submission, she was, because she knows things were not done which could have been done. She knows why they weren't done. And the only question is whether they ought to have been done. And that's the very thing that she ought to seek advice about.
So that's really your case on, well, that's your case on actual knowledge. You've done your case on constructive knowledge in 2008, 2009.
Yes, I've certainly delved into the facts much more than I anticipated. But I was going to spend a little bit more time on the factual side of things, but I can take this much more quickly because I've covered quite a lot, if I may. I suppose no, I think I've covered that. So just looking at why, with a focus on the facts, the judge was right. With the position at the end of 2009, first of all. And the judge observed, and this is paragraph 96 of his judgment, he found the appellant to be a very switched-on lady. She had a degree in design, a master's in environmental research and design. She'd been earning £70,000 a year in about 2000, before giving up work with children. And the evidence was that, for instance, had been trained as a magistrate. She'd put together the Hildebrand bundle herself. She was interested in the legal principles. You know, she held her own. She had a mind of her own. At one point, it's in the supplemental bundle at 27. We saw it earlier. She'd been off to the library. She looked up the family court practice for Dilbert books. She does some company searches at one stage. So I mean, you know, none of that matters for constructive knowledge, but it matters for actual knowledge. She knows the powers the court has. I mean, one document just to illustrate that point, if I may, we can look quickly at the supplemental bundle at page 8. One of the things the form of order will typically do in the event of a settlement, as occurred here, is to recite which claims are being given up as part of the settlement. So you want to see it clause 3, save as aforesaid, claims for financial provision, whether periodical payments, secured provision, lump sum, pension sharing, pension attachment, property adjustment, stand dismissed. So that just adds to the picture in our submission of the this claimant being well aware of the range of claims which existed. I've been through the particulars of the claim, but can I just, for your, so far as the evidence is concerned, for your lordship's notes, the claimant's statement at paragraphs 28, 32, 36 to 40, the claimant speaks to a belief in the her ex-husband's manipulation of the financial position and concealment of his true financial position, that he hadn't given full disclosure, that he had a higher earning capacity than he claimed, believed he had an interest in Woolhouse and it was unfair, and he'd manipulated the position, and so on. So that was that aspect of the factual position, and she confirmed that when cross-examined. We submit again. She knew more could have been done. I mean, that was the big question, was whether to do more. She knew there was a plan B. And she knows that the solicitor is instrumental in advising her to choose Plan A, to choose the settlement. And there's a remind your lordships of what my client is said to have advised, particularly of Claimant paragraph 41E. If I could just read it, we've seen it. That she was a strong woman. She didn't need to worry about the maintenance, pension, or the house. She could start again. She was young. And in her statement, at paragraphs 34 to 35, there is a similar recitation of the advice from the solicitor and the encouragement from the solicitor that needs her to settle. So that's the position at the settlement. And then within a year, we've got the realisation of just how inadequate and unfair the settlement is. Not just the portion of the new business, not just, as it were, some subsequent developments, but the confirmation that gives that there's been a manipulation of the position, that she hasn't been dealt with fairly, that her husband has considered assets or the means to wealth. And if we could look, please, at the supplemental bundle see how this, one of the emails we get at page 24 in the supplemental bundle. So this is the 20th of March 2009. My only friend took your lordships to it. I just wanted to pick out a few points myself. So we're in March 2009, and
just give me the page again, sorry.
Sorry, page 24, my lord.
Yeah, sorry. Yep.
What we get is a recitation of difficulties and goals. Matter Cottage in the sole name. No requirement for her to repay the mortgage payments which her ex-husband is currently bearing, which will take £25,000 out of any proceeds of sale. She wants 100% of the claim against the builders instead of, I think it was 80%, and the possibility of remortgaging Manor Cottage so she doesn't lose it, and him to contribute the rest as a term basis maintenance payment. And the difficulties at the bottom: family not saleable, economic downturn, significant drop in the value of the property. We can see that again picked up over the page at 3, and the further predicted drop, still rectification work to complete the property before it's ready for sale, leaving the claimant with negative equity. And at 5, please be assured I make these remarks in the essence of trying to achieve fairness and compensation. There's been a material change in circumstances. I would now like a fair deal. So I accept that some of that is subsequent developments, but nevertheless, the overall appreciation is that this is in the working through, proving this to be a wholly unfair and inequitable deal, leaving the claimant with the prospect, even of having no equity, no capital whatsoever. Whereas the position of her ex-husband is obviously dramatically different. And so she knows all that, the poor and unfair result, and she discovers nothing can be done to reverse the position. interesting. It is some time after the event, but as we have the supplemental bundle, could we just have a look at page 56? Because what we've got at that document, which begins at page 47 in the supplemental bundle, this was referred to at trial as the Project Magpie document, which the appellant drew up in late 2018, setting out the history of her marriage, of her financial affairs as between herself and her ex-husband, and about how events had developed.
What's the date of this document?
It's January 2019. 13th of January 2019, I'm very grateful. So your lordships will remember that the file had been obtained from my clients in May.
Yep.
And at the start of 2019, one thing the claimant does do is to put together this, as it were, briefing document, setting out her own perspective on...
Is this after they've read the file, or do we just not know?
About the same
It's about the same time, because he didn't look at it until January, did he?
He didn't look at it until January, yeah.
Anyway, sorry, yes.
I mean, just a few little details, if I may. Middle of the first page at 47, no pension allocation. Mary didn't want to look into the Guinness Marm Trust pension. No spousal allowance. He moved us out, so we have no claim on Bull House. So what you can see, looking back, the claimant is still able to understand and appreciate exactly what was at stake, exactly what could have been obtained, and exactly what wasn't obtained, and how she's been left off. At page 48, second paragraph, the claimant received a £100,000 balance from the sale, that's of Manor Cottage. Ex-husband recouped all his mortgage payments and paid for legal estate agents. He paid nothing. In August 11, I moved in my parents and my children into Mr. Zumby's bungalow. We had nowhere to live, and Mr. Zumby owed my parents their money, secured with a charge on his land, or so I thought, and me money that was unsecured, which I've never recovered. And now we could take your lordships to page 56, where the claimant, as it were, looking back, summarises the position. I lived in a £1 million house, that's a reference to Wall House. I had £1,000 a month insurance cover, children at private school. I stayed at home to look after our children after giving birth. I gave up an environmental consultancy of £70,000 approximately to have a family. I was moved out of Wall House, issued with divorce papers. I ended up with a house I couldn't afford, no income, no pension, no insurance, no maintenance. Reasons for his vicious behaviour. He found out I'd been to see a divorce lawyer in August 2005 with a very close friend of mine. I'd gone to help her, but he thought it was for me. I took legal advice from Manchus and Martineau's. The first overbilled after an agreement of £15,000 only for the whole process, and I sacked them. Then Martineau's did not fully investigate based on my limited budget. I then had 2 years of CAFCAS, and then met Mr. Zumby, who subsequently took what was left of mine and my parents' finances. So, my lords, I just picked that out, but it demonstrates in my submission what has always been the case, which is that by the time you get to 2008, 2009, there is an acute sense of a disastrous outcome and of the possibility even of negative equity, of no capital surviving for this claimant. And we say that difficult as those circumstances were, that isn't just knowledge, actual knowledge of damage in circumstances where she knows that the settlement could have taken a different form, could have taken a different form, not should, but could have been much more generous, could have been much more equitable. She knows someone of that ability, someone of that interested, someone that articulate, has reason to know that there is a possibility, almost as a logical necessity, there's a possibility that that could be due to deficiencies in her legal advice.
Well, the sentence, Martineau's did not fully investigate based on my limited budget, might be said to be a one-sentence summary of the particulars of claim.
I don't know, because based on the limited budget, it might mean that back in 2008 the claimant appreciated that or perceived the matter as based on the fact that she didn't have much money, so the defendants weren't in a position to do much. So it's entirely understandable that they gave the advice they did, and no alarm bells ring.
Well, how could you have been left in this situation? The outturn was so unfair. It's so unfair, and you know that buttons were not pressed which could have been pressed. And the only question is, ought they to have been? She doesn't know that. Of course she doesn't. She needs to go to take inquiries further. But is it reasonable to begin inquiries for the purpose of actual knowledge? Is she at that stage that Lord Nicholas describes? Is she at the stage in which there's some reason to question the adequacy of the advice? If you're ever going to do so, I would say. And it's, if not now, then when? And so my submission, yes, is the answer. It's not an easy conclusion, and one has a lot of sympathy, of course, for the position the claimant was in. But it is the appropriate conclusion. So that's actual knowledge. Even if that's not right, then it's a Forbes case. Because it is such an unfortunate state of affairs that an active and inquiring claimant, which is what the statute requires or presupposes, or at least that's the nature of the opportunity you get as a claimant under the Parliament's compromise, would take further steps. It might take, so we'd now have to make some allowances for how long that would take. And it might take 3 months, 6 months, whatever. But it's still obviously way in the past, so far as the present claim.
Do we know why Mrs. Edmonds said in May 2022 the solicitors were at fault? Did she say that in the context of they should have investigated, or they should have kept the option open? Because if they took advice in 2019, the advice would have been if you didn't have the money to pay for the investigation, they wouldn't go ahead. So do we know from the fact, or do we not
don't
know?
I think my little friend, and he will know it better than me, was that the evidence was to the effect that the barrister said the real villain of the piece is Martineau Johnson, something of that sort. So
The real culprit.
the real culprit.
The real culprit.
So a generic description rather than an analytical exercise.
And we don't know what she was told about. I mean, you might see that if you're told there's all these assets, he's been full of money and she hasn't got anything. But if she'd been told about the budget, I wonder whether it would have been different, or we don't know, though, is the short answer.
We don't know. I mean, I think there was a further exchange of apprehensions in particular, because Mr. Morgan put in an email to the barrister, well, is this possibly a case in which there was a failure to seek proper pension provision? We don't have an answer to that.
No, because I was wondering, because I mean, it's all turning on the non-spousal maintenance order, whatever it's called, at the moment, because the other things could have been investigated or dealt with at the time. I just wonder whether but we don't seem to know whether that was the nub of it. Gosh, this has gone wrong. Just look, they overlooked one major trick, although I don't see that the major trick was a major trick at the moment, because even if you've got the non-spousal maintenance order, which allows you to go back, you still haven't got the money to do the investigations.
No, I mean, there's no indication in the evidence that I recollect that counsel said anything specifically about non-spousal.
Other than this is with the culprits.
That's my understanding. So, my lord, I was just going to come to an end with actual knowledge. And I think that's it. She knew enough to investigate further. Or constructive knowledge Forbes. Just one point, and I think I can deal with it in a minute, if your lordships will humour me, as it were. I think I've really addressed this already. Does the fact that for constructive knowledge purposes, does the fact that the claimant went back to my clients enable her to rely upon the proviso? And again, there are two answers to that. One is no, because she's got to show she's undertaken all reasonable steps. And in the circumstances, the effect of going back to my clients was simply to be told it's a fait accompli. That, if anything, as the judge found, ought to have focused your attention on the only remaining possibility, which was that you might have been ill-served by your lawyers. And secondly, in any event, the Forbes point, there comes a moment when the dust settles and when you reflect on where you have been left, and in this situation, the situation was very bad and it got worse, you have an obligation to inquire if you're ever going to do so. So if it's a case like Gosden and the solicitors don't tell you about something they've obviously got wrong, or if it's a case like Morris where they drafted an earn-out clause which was nothing more than an agreement to agree, and they tell you, well, there's nothing wrong with that clause, and the other side are completely wrong when they say that is an unenforceable provision. Well, of course, that, it's unlikely that in those circumstances the court is going to say that you're not within the proviso because you've gone back to your solicitor and they've led you to think that there isn't actually a problem, or at least they don't alert you to the problem, when they have an obligation to do so. But there's nothing of that sort in this case. The claimant is left with the very difficult situation, and she needs to address the question, is it possible that this is due to deficient advice? Have I been badly served? And she has a sufficient cue to do so in our submission on the facts of the case. And well, she decided to move on with her life. I mean, if I can give the reference at 150D to 151H in cross-examination, what she says was, and I'm paraphrasing, well, my circumstances were very difficult. I didn't think there was anything I could do. I moved on. Well, that's what Mr. Forbes did. No one could criticise him for that in any, as it were, moral or any other conduct sense. But it's not what the statute requires in our submission. Well, that's 2008, 2009. I was going to pick it up with a later period after lunch.
So that's a very convenient moment to break 2 o'clock.
Right, able.